Unit 6, Law of Succession, Lecture 4, Testamentary Succession. Testamentary Succession. If a person passes away without a valid will in place, we said interstate succession will take place, but one of the most important parts, what is the importance of having a valid will in place? You can choose your heirs and beneficiaries, the persons that inherit from your estate. You choose the trustees in a testamentary trust. You can nominate your executor, the person that winds up your estate. You can negotiate a fee. You can provide special instructions and directions regarding the distribution of your estate. You can make special provisions, prescribe the extent of entitlement, for example, a usufruct, and make use of any estate duty concessions. Here we have a list of specific definitions with regards to the Wills Act. All of these definitions are in your Fundamentals of Financial Planning textbook on page 447 and page 448. What are some of the formalities to execute a valid will? It must be signed on every page by the testator, person that drafted the will, either by making a mark, a thumbprint, or a cross. If a testator is unable to sign the will, they may appoint someone to sign on their behalf, but this must be in the presence of a testator. A will also has to be witnessed by at least 2 competent witnesses on the last page, and this must be signed in the testator's presence, or they must acknowledge the testator's signature. And who is competent to draft a will must be at least 16 years of age, mentally capable of appreciating the nature and effect of the act, and burden of proof rests on the person making the allegations. Can a defective will be declared valid by a court? Yes, according to section 2.3 of the Act, if a court is satisfied that it was intended to be the deceased's will, they shall order the master to accept the document as a will, even though it does not comply with all the formalities. Who can and cannot benefit under a will? The following persons are disqualified from inheriting: a person or a spouse who witnesses the will, signs it on behalf of a testator, or a person that writes a will, except if such a person was an executor, trustee, or a guardian of any of the persons above, if a person was a witness, but there were at least 2 other competent witnesses. If an individual renunciates a benefit to inherit under a will, their benefit will go to their surviving spouse and descendant. Should their descendant also renounce a benefit, that benefit will accrue to the surviving spouse, provided that the descendant is not a minor or mentally ill. This is according to section 2C1 of the Wills Act. According to section 2C2 of the Wills Act, if a descendant has died before the testator, renunciates the benefit, or is disqualified to inherit, their benefit will automatically go to the beneficiary's descendants. If there should be a scenario where 2 spouses get divorced from marriage and one of the spouses dies within a 3-month period, the surviving spouse is automatically disinherited from the will of the deceased spouse. If we explain this by means of an example, Jonathan died on 8 June 2018 and bequeathed his total estate to his spouse and 3 children in equal shares. Jonathan and Julie got divorced on 28 April 2018. Who will inherit John's estate? So between the divorce and date of death is less than 3 months, so Julie is automatically disinherited from the estate, and the children will inherit in equal portions. What if Jonathan died on 8 November 2018? Since the date of divorce, which was 28 April 2018, this is longer than a 3-month period, So in this case, Julie and the 3 children will inherit from his estate in equal shares.